Hi, everyone. Thanks so much for coming tonight. I know that things are a little bit crazy right now and everybody's dealing with having their kids home. So I do appreciate you guys taking the time, and I really hope it's worthwhile. I think it will be. Tonight I had planned this event live many weeks ago. Obviously, that became impossible. And I had planned on going through the process in general and also talking about some of the issues we are facing this year prior to coronavirus. Now it's become clear that I have to also talk about the coronavirus. So we're going to be touching on some stuff in general and also how things may have changed this year, both before and after the virus. A few housekeeping issues. You'll see to the right of the slides that there is a Q&A. You can click on there and ask me questions, and I will answer them for everybody. Just keep in mind, I won't, say who is asking the question, but I will read the question. So if it's private, and you just want to talk to me about it one-on-one, feel free to reach out to me after. Also, do try, I know it's hard, but try to keep the questions general. If it's about your specific case, it'd be better that we talk about it one-on-one. The other thing is this is being recorded, just so everybody knows. I guess I, as a lawyer, feel like I should let you know that. We're gonna sort of jump right in. Some of this is, at the beginning, may be review for some of you who are my clients or who have been through this. But I still think it's important that we're all on the same page. So some of this is going to be, some of you may know some of the stuff at the beginning, but we will get to some of the more relevant stuff as we go through. Yeah, I'm going to get going. And then just to give all of you some background in case you don't know me, I'm Jennifer Ratcliff. I've been doing this since 2011. I've had my own firm since 2017. And so I've been doing this quite a while, although I will be honest, this situation we find ourselves in is definitely a first for me, as I know it is for everybody. So, okay, so starting off, we are going to be talking tonight and in every case about the Individuals with Disabilities Education Act, also known as the IDEA. This is the act under which all special education tuition reimbursement services cases are litigated under, and it lays out the school district's obligation. So the school district is required to provide every student with a disability with a free and appropriate public education. The operative word here is appropriate. So I think we all kind of know what free public education is. It's appropriate that we litigate under the law. So that's what we're going to be talking about tonight, and that's what we talk about in most special education cases. Every special education case has three parts to it. So the first part is the district's burden. Have they offered a free appropriate public education? That's their burden, although we as parents, attorneys, and parents have to work to try to prove that they did not do that, even though it's entirely up to them to prove it. We always have to also disprove it. Then, is the parent's proposed program appropriate, the private program or the services that we're seeking funding for? And the last part is equities. Equities has to do with whether or not the parent impeded the child's ability or the district's ability to give the child a FAPE. So did they, did they impede in any way in terms of not consenting to evaluations, not showing up for an IEP meeting, that sort of thing. And you can lose your case based on equities, or the amount that you're awarded can be reduced based on the equities. Most cases revolve around the first issue. Has the district offered a FAPE? That's usually the most heavily litigated issue in any case. The other, usually the parents program is pretty appropriate. I mean, they're usually great, to be frank. And equities is generally not a problem as long as you have a lawyer sort of guiding you on what to do and what not to do. But, you know, it is tough because the school district, if they find that the school district did offer a FAPE, that is, it won't matter how great the parents program is. So that's the only question. And if they did, you know, that's kind of game over. So that's really the critical piece. So those are the three parts of a funding case. Next, we're going to talk about evaluations. Evaluations really do two things for parents. First of all, they give the parent and all of us a roadmap as to what the child needs. That's helpful for parents, case or no case. I mean, if you get a great private evaluation, it's really worth its weight in gold. It is very expensive sometimes, but you're getting invaluable information about your child. And that sort of guides us in terms of what type of program we're going to be seeking funding for. So a lot of times I have parents coming to me and they'll ask me, do they have a good case? And the answer is, well, in terms of the district clearly failed, but the question then becomes, we need to know a case for what, right? So it's the neuropsych that really gives us a sense of, okay, what does this child need? They're also sort of the expert opinion in any tuition funding case. So by that, I mean, the neuropsych can really show up at the hearing and sort of give the third party objective doctor's opinion on what your child needs. So it sort of mitigates any argument that the parents are just seeking what they feel is best for their child, but it's not really what the child needs, and therefore the district shouldn't have to pay for it. So it really does help us in terms of providing a basis for what we're asking for. In terms of evaluators, when you are trying to find an evaluator to use, now I will give you a caveat that, you know, both myself and most attorneys and most private schools have a list of great evaluators that they've worked with, and that will, you probably will be pretty much can't go wrong with that list. But if you want to seek people out on your own, that's totally fine too. There might be a great, you know, evaluator I don't know about. I'm always looking for new people to recommend, so I'm all for it. But I think these are three questions you should really focus on when you're asking, is this evaluator a smart choice for me? So first, will you attend an IEP meeting or hearing, and do you require an additional fee for doing so? So most evaluators, like most people, will pretty much do anything if they get paid for it. So the truth is most people will attend an IEP meeting or hearing, even if it's not their policy, if you pay them for it. It's the if you pay them for it, that's the issue, because some of them have it built into their fee and some don't. So that's a good question to ask right off the bat. And some, I guess, maybe you could say it's their policy to not do that, even if you are paying them. And that could be an issue, because I don't want you to spend so much money on an evaluation that then you can't use this person as a witness in a hearing later on if we need them. Also, what experience do you have with the tuition funding process? Really important in terms of, you know, I think you're going to see throughout this presentation, this is not exactly simple. So having some sense of what's involved, I think, is really important. And then also, will you work collaboratively with our attorney and our child's school? Again, really critical. And the answer, you know, if they don't have as much experience with the funding process, if they're a great evaluator and willing to work with us, I'm happy to work with them, but I think there has to be a willingness, because if you're seeking tuition reimbursement or reimbursement for a program, you are not just in it to have a great evaluation of your child. Of course, that's excellent, but if you're going to pay for it, you might as well also get something that's going to help your case, I would think. So really critical. I do want to say one word about funding for evaluations. I didn't go very specific into it in this presentation because I just didn't want to, I have to pick and choose basically what I'm going to talk about. But I do want to say a quick word that you can sometimes get your private evaluation paid for by the district. I think that's why it's really important to go see a lawyer before you engage with an evaluator, because sometimes I have people coming to me and they paid, thousands of dollars for an evaluation that they maybe could have gotten for free or could have gotten that money back. But we didn't do what we needed to do, and now it's kind of too late. So, not the end of the world, but it's still a lot of money that you didn't have to pay. So, I think I'm not going to go into the intricacies of how that works tonight. I'm just giving you the caveat that maybe if you're a parent or if you're a school administrator, and I was talking to somebody about this just last week, but I forget which one of you it was, that you want to make sure that maybe they're talking to a lawyer first before they commit to an expensive evaluation. Just as a by the way. Okay, so that's evaluation. So you go through, you find out now what your child needs, and it's time for you to now send it to the district and go forward with the process. So the first thing the district will most likely do, either if your child is starting in kindergarten or is starting a new school year, is they'll schedule an IEP meeting for you. What do you want to do before that meeting? First of all, you want to collect all your evaluations together, assessments, progress reports, and have them on hand. This is the part of the presentation where we start to talk a little bit about Corona. So typically I tell parents, make sure you bring a hard copy into your meeting, because shockingly the district is not very organized and they may not have it or have everything you sent them so meticulously. We're in uncharted waters. This is why I typically don't like parents to do IEP meetings over the phone, but we have no choice. So we have to make do. I think you want to make sure that you're sending these evaluations, progress reports, the day before, maybe even twice, like the day before and then an hour or two before. You want to make sure you have them. And then when you're on the call with your IEP meeting, you want to say, okay, does everybody have the reports that I just sent? And then you can sort of get a sense of what everyone's looking at. Also, before your meeting, you want to inform the participants that you want to have come with you. So child's school, your neuropsych. In times gone by, I definitely said you could have your child's school and your neuropsych on the phone while you're in person. Obviously, everyone's on the phone now. That goes without saying. Also, you can have a support person with you. Again, a little bit odd because no one's going to be in the same room, but you can actually bring a friend if you don't want to go alone. So I always like to remind people of that. But I would tell the school district who you're bringing, and I would let those people know of the date well in advance, as much as in advance as you possibly can. Also, you are allowed to schedule, reschedule if necessary, within reason. You can't reschedule it 5 or 6 times and think that you got to be flexible. but you can reschedule. Just do it as soon as possible. And I didn't add this, but if you have a lawyer, you should talk to your lawyer. Let your lawyer know about the date. And for me, I don't typically go to IEP meetings. Most of my colleagues that I know don't typically go for various reasons, which basically it could increase. There's not a lot of gain, and there are some losses to having attorneys go. Under certain circumstances, it makes sense, but under a lot, it doesn't. So anyway, let your lawyer know so you can make that decision with your lawyer, and then most likely they'll at least want to prep you before the meeting. At the IEP meeting, what you want to do first and foremost is to use the private report that you have, private progress reports, any reports that you have that support what you're trying to accomplish as sort of your backbone for what you're going to be discussing. So you want to talk about, you want to talk about what your child needs by using the recommendations in those reports. It's really pretty simple. That sort of, again, mitigates any talk of, oh, this is just what the parent wants and not about what my child needs. I think really, really, really critical is to actively participate. I think sometimes people think, well, I'm sending my child to a private school, so I don't really care what they say, and I'm just going to sit here. That's not a great strategy. I mean, I invite you and encourage you to, if you're going to send your child to a private school, or you at least have that as an option, to allow that to make you less stressed. At least you have a plan B, so to speak. But don't let that make you not participate, right? So because let's say you are going to sue for that private school, and 6 months down the road, we're in a hearing and I start talking about all the things that aren't in the IEP. And now you've got a district witness saying the parents didn't tell us that this was even a problem. So you can see why this could be a big issue. You really need to actively participate. Point out when you hear something that isn't right, or contribute when you feel something's missing. And talk about maybe, what they're saying that does make sense. Just participate as you normally would, but be careful with your language. So you want to mitigate, again, this idea that I want what's best for my child. Of course you do. In this job, I have to tell parents to talk about their kids in very unusual ways. So no parent that I know ever says, I want my son to make, appropriate progress. Like, that seems completely ridiculous to say. But the truth is, they're not required to provide your child with the best. And they're not required to maximize your child's potential. There's case law that actually says that. So even if I know it sounds harsh, but that is what the case law says. So instead of saying appropriate progress, that seems a little clunky, you could say, I always tell parents, my child needs this, my child requires this, my child won't make progress without this. Those types of things that's the type of language I would use. You want to keep a cooperative and calm tone. So cooperative doesn't mean agree, but you want to be collaborative to the extent that you're allowed. And even if they are not so wonderful, and sometimes they are lovely, but sometimes they're not, you don't want to get worked up. I know that's hard, but it's really not a great idea. You're just going to wish you hadn't. The truth of the matter is CSE meetings are not really a collaboration. I would love if they were. It's the DOE's game. Not game, maybe is kind of a harsh word, but it's their home turf, so to speak. So you're kind of up against it. They make the final decision. You shouldn't let that get you down, because that you have the alternative to get a lawyer, or you have a lawyer, and if need be, we will escalate the issue. We will file a case for due process. So keep that in the back of your mind and just try to remain as calm as possible. Again, as I said, though, cooperating does not mean agreeing, so you don't want to sign anything. Absolutely nothing except for the sign-in sheet. I cannot emphasize that enough. Because God knows what you're agreeing to. If they're pushing you, do not give in. I know it's hard, but you don't want to lose out. If they say to you, if you don't sign this now, your child's not going to get any services, that's not true. So just, don't worry about it. One thing I say to parents is if you're there by yourself, you can often say you have to consult with your child, with your spouse, your child's, the other parent if they're not there. If they're both there, you can come up with something similar, some type of reason to delay, but you really don't need a reason. But if that makes you feel better, you can come up with one. And you want to end the meeting by agreeing to disagree. So essentially, I let you know what I have problems with. I still think this is an issue. I'm happy to look at whatever you have, and I'll get back to you then. Keep in mind, though, that with coronavirus, so typically you would get the IEP after the meeting, unless it's a preschool meeting, and then you'll get a school placement. You're not really this year going to be able to visit any schools, so that sort of throws a wrench into it. But you can at least say, look, I want to see the IEP on paper. I want to see, what school is offered so I can reach out to them, that type of thing. So you still want to keep that same tone. Now, I've added this in for phone meetings, again, which I never in the past have recommended, but we have to really, we have to now realize that's the reality. You want to get clarity on which documents are being referenced, because it's going to be the tech that the DOE works with is like really low. Like what I'm doing right now is like high tech. Okay. So this is like, you're not, it may not be a great connection. You're not really going to know who's talking. You have to, you're going to have to intervene. If you don't know what they're talking about, who's saying what, do not be afraid to step in and say, wait a minute, I didn't get that. The line broke up. Who's saying that? Also getting clarity on which documents are being referenced. Which documents do they have? You're just going to have to do your best, I guess, in some ways, to just kind of create a sense of, being able to tell those things that you would be able to know if you were in the room. And do not be afraid to speak up. We're just going to have to be a little more proactive about that. It's really not ideal. I wish that they could do a Zoom or something, but they just don't really have that technology, shockingly. So after the IEP meeting, you want to take notes. Some of my clients feel comfortable taking notes in the meeting. Some can't really, which is understandable. They're too focused on the meeting, understandably. So, but you want to take some type of note like that day or the day after, so it's fresh in your mind. I can't tell you how many clients have sat with me on the morning of the hearing, looking and referencing their IEP meeting notes and saying, thank God I took these notes, because I don't remember anything that happened at this meeting, or I don't remember very much of it. And you want to send those to your lawyer. And you maybe even want to send them to your school, especially if they participated, to see if they have anything to add. All of that is extremely helpful. You will thank yourself later, trust me. You also may need to follow up in writing. So again, after your meeting, you want to talk to your lawyer, and they will tell you, do you need to follow up in writing with a letter, explaining anything, clarifying things. Sometimes it's not necessary until later. Sometimes it's necessary at that time. So you just have to talk to your lawyer and sort out the strategy. Address any lingering paperwork. So you may be in the meeting, they may give you homework, so to speak. They may say, oh, you want PT? Okay, well, you need to sign a consent form for a PT eval. Again, talk to your lawyer before you sign anything. But in general, I will tell you this, in general, consent for evaluations is almost always fine. But they may give you other homework. You never know. So you just want to keep track of everything that they told you to do, because what you don't want is, even if it seems ridiculous, and usually it's not, but sometimes it is, you don't want a situation where they're saying, well, we were waiting for the parent to do X, Y, Z, and that's why we didn't send an IEP. That's an equities problem that you'll have at your hearing. So address all that stuff right away before we all forget about it. And then all you need to do after that is checking your mail for your IEP. If you're going to be away because it's summer, have somebody check your mail for you. I don't know how many people are in that situation right now that we're going on our wonderful Caribbean vacation for 2 months, but I hope that we will in the future. So for future reference, when you're not glued to your apartment, you should have someone check your mail if necessary. And you also want to send your IEP to your attorney, and really probably your private school as well. They're probably going to want to see it. So after you receive an IEP, either when you receive the IEP or after that, you are going to get a school placement offer. Now, this is where things are a little bit dicey right now. Typically, what you would have done was you go visit the placement. And I have helpful sort of questions here to sort of address. I got to be honest with you. I'm not entirely sure yet what this is going to look like this year. Obviously, I mean, it's my personal opinion that this is going to be completely unavailable to us for this year. I don't see them letting anybody in to visit any schools, even when there aren't kids there. God knows, maybe in July, maybe August, who knows? But so this is going to be an evolving thing. So I give you that caveat as I tell you this. I think, and I got to be honest with you, I haven't completely decided this yet, but I think I'm going to have my clients, to the best of their ability, reach out to the CSC and the placement to ask their questions via email. I think it may be the best we can do. But, keeping in mind that that's evolving, the types of things that I typically want answered are how many kids and adults would be in the classroom, what types of disabilities are the kids going to be with, what experience level is there of the pairs and the teachers, what related services would they receive, and in what environment? So are they going to be receiving them in the hallway, that type of thing? Methodology and curriculum. So is it ABA? Is it TEACH? Are they going to do Orton-Gillingham? Does your child need Orton-Gillingham and they're not doing that? And support in the environment, and the environment during things like lunch, passing period, recess, music, you name it. I'm going to be honest, the answers to these questions are usually pretty disappointing. I mean, they're usually something like, we follow the IEP and methodology is decided by the classroom teacher. And, it's not usually very satisfying, which, to be honest, is the reason why the visit can sometimes be so helpful. So it's unfortunate that although sometimes the visits are not helpful, it's a mixed bag, but it is unfortunate that we can't go this year to check it out in person. It's going to be evolving. I'm going to try to figure out some type of a strategy and work with my other special ed colleagues to sort of figure this out. But for now, I think you still want to be asking these questions. If you have to ask the CSE team, if you have to reach out to the school, it doesn't really matter what the answer is. I mean, it does, but if you have that plan B of a private school, the truth of the matter is, if their answers are unsatisfactory, their answers are unsatisfactory. It's more about you asking the question than the actual answer. And oftentimes when parents ask me, what should they ask the placement about? I say, you should vet it like you would any other school. So, you want to, any school that you would send your child to, what types of questions are important to you? And that may be different for different people. example, some parents don't, they have children with very severe sensory issues, and a very loud bell will really upset them. So these types of things, so they ask every school that, how do you sort of signal that a class is over? If that's important because that's what affects your child, that's what you should be asking. So, this is a jumping off point, but please be asking these schools any questions, and ask that at the IEP meeting as well. They're going to tell you it's up to the individual school and they don't know, but ask the question. It's more about that you asked, that you were active, that you were willing to accept a public school program, and then put the ball in their court. Let them tell you that they can't tell you. Let them tell you an answer that's unacceptable. That's really the focus for you. So you've done your visit. You've gone to the IEP meeting. You have your IEP. You have your program. Or maybe you didn't, right? Maybe they didn't give you a meeting. Maybe they didn't give you an IEP. Maybe they didn't give you a placement. But whatever the reason, either you didn't get what you should have got or you got something that was unacceptable, you've decided now that you are going to seek reimbursement or funding. This is the timeline for that. Now, I give this caveat extremely strongly to any parent or school who is listening. This was something I created 3 years ago when it took 9 months. That's not how long it's taking, and it's not a coronavirus thing. It's things are very difficult this year thing. So I would say, as much as it breaks my heart to tell you, you have to double this. It's about 18 months. And I feel, this is the card I created, so I put it up, but I do feel bad. I don't want anyone to get misled. So I try to really give everyone that caveat. I'm going to go through the card with you now. For some of you, this might be review. For some of you, this might be confusing, but I'm going to do my best. So whatever the case is in your case, you didn't get an IEP, you did get one and it wasn't very good, or wasn't good at all. You've decided you're going to do a special ed case 10 days prior to your school year starting. So your child may start in July or they may start in September. We send out a 10-day notice. That's either mid-June or mid-August. And the 10-day notice basically says you didn't do what you were supposed to do, and now we're going to seek reimbursement for XYZ program. Once that's sent out, that is sent out prior to the school year. That's pretty much a hard deadline. My office does that. Then at any point after the child starts at the school, which, is about 2 weeks later, and you have 2 years to do this. So any point, from that point forward, you file an impartial hearing request, also known as a due process request. That is the actual case, so to speak. So that's the lawsuit. You file that with the hearing office, and then we enter a 30-day period called the resolution period. This is a period of time during which the district is supposed to try to resolve your case. In New York City, in a tuition case or reimbursement for tuition or services, the resolution period is kind of useless. I mean, to be honest, they don't allow people to participate from the district who have any authority to settle anything for money. So that's really not very helpful to 90% of my clients, 95. They can issue evaluations. They can reconvene an IEP meeting, and in a handful of my cases, it's useful. I'd say the vast majority of the time, they don't even schedule one. So it's kind of useless, to be completely honest, in New York City, unfortunately, because it could actually be a great tool. So typically that 30-day period kind of runs without much happening. Of course, if you could resolve it in resolution, that's something I would tell you. And then the so once you file your hearing request, you're the idea is that you're assigned a hearing officer, right? This is one of the difficulties that we're facing right now in New York City before the virus. This is pre-corona, trying to give all of you perspective. We are facing an unprecedented shortage of hearing officers who are the judges in these cases. The problem is that they weren't being paid on a regular basis by the DOE, just like many of the schools and providers weren't being paid. There was a lot of press about this, so I have a feeling most of you read about it. But they kind of went, pseudo kind of went on strike, but also sort of became overwhelmed by their caseloads and they weren't getting paid, and it was just kind of a big mess. Anyway, we ran out of hearing officers. As hearing officers finish up old cases and are able to take more cases are getting assigned a hearing officer. But from about Thanksgiving forward, any new cases that were filed didn't get a hearing officer assigned. Myself in my office, I have a handful of cases in this situation. Other offices also have it. There's actually, last I checked, there were 3,000 cases without hearing officers. I'm sure that has increased. So it's not a small portion of the cases that are affected. I'm going to go through this the way that it should be, and to give you at least a background on that, and then we'll talk more about the problems that are happening this year at the hearing office. But essentially, assuming it goes the way it's supposed to go, you're assigned a hearing officer. And around the time when the resolution period ends, they will contact you in the district and they'll ask you, is the case going to settle? Is it not going to settle? Most hearing officers will allow a few weeks, a couple of months, maybe even, to sort of see if the matter will settle, right? And eventually it may. So let's say they decide that they're going to settle the matter. They let you know that. That's what's kind of referred to as being in for settlement. We're following the green line, just so you know here. After that, our office collects documents, financial documents, we call them, but they're like a school schedule, tuition, affidavit, which says what your total obligation of the school is, attendance records, that sort of thing. It's like 5-6 things. And then after that, we negotiate. Negotiation consists of me, on email, going back and forth with the district. I do the negotiating. The parents don't do it, but I let the parent know what's happening. After we've agreed to a number, and generally speaking, the numbers are good, right? If we're going to settle, 9 times out of 10, our settlements are good. They've just been very generous lately. That is one good thing that is happening over at the hearing office right now. We draft the stipulation, which is the settlement agreement. The parent would sign that, and then the DOE would also have to seek comptroller approval. This is the part of the process that takes a while. Once you've agreed to a settlement, the comptroller has to approve it before the district can sign it. My personal opinion is, so the DOE will blame the comptroller for the delay, because there's generally a delay. But my personal opinion is the delay is not with the comptroller, it's actually with the DOE. That's based on opinion and also just some information that I have. It can be a long, arduous process. And it is made more difficult when you don't have a hearing officer assigned to your case. So again, remember what I was saying about this year, there are a lot of cases I have that are in for settlement that are moving through the settlement process. So they don't need a hearing officer to hear the hearing. But if they don't have that judge sort of on them to settle it and move on, you can imagine there's like a little bit of a bottleneck problem. Let's say they don't want to settle it. So now we're talking about the purple line, which is the hearing route. And just hearing another word for trial, in case you don't, it's what we think of as a trial. There's a period of time, so they don't want to settle. The hearing officer will set dates for the hearing sometime in the future. Sometimes it's, literally that month. Sometimes it's a month later. Sometimes it's a few months later. They're the judge, so unfortunately, we kind of have to work with their schedule. There's a period of time where we prepare for the hearing. My office handles the lion's share of that work. So we reach out to people at the school for witness testimony and documents, and set up testimony with the parents, or prep for testimony with the parents. And then, we go in on the date. Typically, these cases are held in person at the hearing office in downtown Brooklyn. Obviously, that's not happening now. They're being held over the phone on a conference line. I've actually not had to do this yet, but I've actually heard from a lot of people that it is actually much more efficient, which is really saying something, but the hearing office can be a little bit of a disaster. So a lot of the hearing officers are actually kind of liking it. It moves things along more quickly. So let's say you have a hearing date scheduled. A lot of cases these days can be resolved in one hearing. And it is, it's like a trial. So basically, the district goes first. They have witnesses. They ask their question of their witness. Then I have a chance to cross-examine. Then another witness of theirs, I cross-examine. Then I have my witnesses, same thing, exactly same thing. A lot of times the district may not put on a case, so it's just my witnesses. It's very fluid. Every case is different. The district is not always clear on what they plan on doing ahead of time. We sometimes don't know until the day. It's a very odd system. But it is very much, it's an administrative hearing, so it's more relaxed, clearly, because we're doing it over the phone now. But it's also still a trial. So I do try to, have people understand this is a lawsuit and it is a trial, not to scare you, but just to make sure that there's like a level of expectation. Your hearing dates typically won't be consecutive dates. So we'll usually have a first date, and if we need a second, we'll pick it together as a group, at the end of the first day. And it may be a month out. That's very possible. But as I said, sometimes one sitting will do it. After the hearing is over, we have to wait for the transcripts to come back from the hearing office, and that's been better lately. So I'm trying to give you a sense of what's worse, what's better. That's been better. In about 10 days, we get that. And then we can have an opportunity to do a closing brief, so a legal brief. Sometimes I will do a closing on the record orally on the last day of hearing. That's a decision I typically make. I make it very much on a case-by-case basis, depending on what happened. But assuming we have to do a brief, that does take some time, and then the hearing officer will issue a decision thereafter. Now, they have to also be in writing, so also takes some time. One good thing also that's come out of this virus is I've heard from hearing officers that they have a lot more time to write decisions. So I got one in 3 weeks, or I think less than just last week. So that's been amazing. And then we would just submit your payments, copies of your payments, which my office helps with, for the final reimbursement to the implementation office. That is the process. It's a little bit confusing. It's not as, I try to make a graphic to make it easy. It's not extremely straightforward, but in a general sense, that gives you an idea of what it's like, I hope. So now talking a little bit about why settle or why go to hearing. There are actually advantages to going to a hearing. But it's very case specific. But let's, talk a little bit about what the factors are. So settlement gives you some certainty. You know what you're going to get. There's no mean, there's stress to that moment, but once you agree on the settlement, I think the stress sort of goes away because you kind of know, okay, this is what I'm getting. You don't need to take time away from work to attend a hearing. Obviously, I wrote this when people were still working, but you don't have to take time away from your homeschooling of your children to attend a hearing, I guess would be the better way of saying that right now. Not to make light of it, but I guess I have to, like we have to laugh. But, in all seriousness, it can be inconvenient to do a hearing. I mean, you have to go, you have to at least be on the phone. You have to get prepped. The school has to get prepped. I mean, it's not that hard, but it is, it's not as simple as a settlement. And it's less emotional. I guess I always try to sort of bring this point up to parents because I think it's the one that surprises them the most. The other two are sort of obvious. I think people are shocked how upsetting a hearing can be. You're hearing people talk about your child in very stark terms. And they're not really talking about the positive aspects of your child. So it can be really upsetting. It can be really upsetting to have a group of strangers talk about your child in like clinical terms. You have to factor it in. It's not something you should just throw by the wayside. It can be more upsetting, I think, than people realize. Those are the advantages to settling. What are the advantages to going to a hearing? Well, I think skipping the first one because that's the most complicated. First of all, you have the chance to get everything. Most hearings give you, if you win, you get everything, usually. Especially like in terms of the tuition. Sometimes there's incidentals that you're looking for that you don't get, but the bulk, when you're talking about the tuition, you tend to get all of it. Usually. You also can get attorney's fees. You can get those in settlement too, but they've been very stingy lately with the attorney's fees. And even when they weren't as stingy, it's not a guarantee, and you're probably not going to get all of them. But in a hearing, you can. You can get resolution more quickly in a hearing. This I say with an asterisk next to it, a caveat, because the implementation office, so that's the office that's supposed to pay hearing officers and providers, and that's the office that's gotten a lot of bad press this year, is the one that pays out on hearing decisions. So I kind of cringe to say that you can get resolution more quickly because the checks have been taking forever. I mean, I just have to be honest with you. When you have a hearing decision, it gives you some kind of control, right? So if you have an order from a judge, and that's what a hearing officer is, saying to pay XYZ and they haven't done it, you can go to federal court and get that enforced. You have a lot more leverage. If you have a settlement that's just kind of sitting there meandering and they're not signing it because they just can't be bothered to ask the comptroller for approval, you got less control. So even though the money is very poorly run right now by implementation, you have that, if you win at hearing, you have a lot more, in my opinion, cachet, so to speak, in terms of getting that money back. Now I go back to the top to talk about pendency. Pendency is a tough concept to understand. So if you're still struggling to understand it because you've heard this 1,000 times, or this is your first time and you still don't understand it, don't feel bad. It took me, actually, to be completely frank, it took me a while to get it myself. We have whole, discussions about it because it can get very complicated. It's the most complicated, honestly, piece of this whole process. But with that caveat, I will say, I'll give you a sense of what pendency is. So if you go to hearing, let's say you're going to, you're at Manhattan Star for the 1920 school year. And we go to hearing and we win. tuition for Manhattan Star Academy for 1920. And then I have to file your case July 1st for your child for the 2021 school year. As soon as I file that case, I've invoked what's called pendency, meaning that from July forward, as long as the case is opened, the district has to pay either you, if you're paying Manhattan Star, they have to pay you back for your tuition, or they have to directly fund Manhattan Star Academy. Now, of course, like everything else, I hope you are getting a theme by now. This is a problem in New York, okay? So the problem is the logistics of it, right? So in New York City, they require you to get an order for pendency. Everywhere else in the country, they'll automatically start paying it. In New York City, we have to actually trudge down to the hearing office and get an order saying there's pendency for Manhattan Star. And then, of course, as I just said, once you have your order, they decide they're just not going to pay that for another 6 months. So logistically, it can be complicated. But I think, first of all, we don't have to go down anymore anywhere because we're doing this all from home. But we still do need to get an order or an agreement with the district, and then we have to actually force them to pay. But at least you know that that money is coming and that you're owed that money. And one really interesting and kind of fun fact about it is that, let's say, you know, you have pendency, worst case scenario, then your case for 2021 goes to hearing and you lose, okay? Not likely, but possible. But say it's May. You don't have to pay any of that pendency money back. So you just got a full year, paid for, and you don't have to get any of that money back. That is really an incentive for parents to go to hearing, as you can imagine. I mean, that's because you do not get pendency in a settlement. So that's why, it's an advantage to going to hearing. It's an amazing thing to have. It's a great insurance policy. Again, even if they're not paying you out and you're pulling your hair out because they won't, they're not doing what they're supposed to do, at least you have the sense of like knowing that you're entitled to it and it will come. Pendency is an automatic right. You don't need to fight for it. If you still don't understand pendency, feel free, please. I actually definitely reach out to me because this is hard in this format to make sure that everyone's understanding what I'm saying. So if pendency or anything else is confusing, after tonight, you shoot me an email, we can talk and I'll explain it better, explain it in a different way. I don't know. I'm hoping everybody kind of understands it, but it is hard. So just know that that's a great benefit of going to hearing. And again, as I said, going to hearing versus settlement is like so case by case. It depends on who your hearing officer is. It depends on the facts. It depends on how much time you can spend. It depends on who's paying out the money more quickly that year. So many factors. It's really something you have to discuss with your lawyer. And of course, and it's kind of, I would think this goes without saying, but of course, not everyone is a lawyer, so I should not make that assumption. If the DOE wants to take your case to hearing and won't settle with you, you don't have a choice. So this is only if you have that option. If they want to settle and you're thinking it might be better to go to a hearing, or they want to settle, but they are not actually doing it and they're dragging their feet. So this is if you have that option. That's hearing versus settlement, okay? All right, now we're going to talk about Connors versus Carter funding for a few minutes. So these are both ways that you can get paid by the DOE. This has to do with payment and how it comes in, okay? So most people have heard of Connors versus Carter, but sometimes when they come to me, they don't know what Connors is. So Connors funding is basically when you pay little to no money up front. And that is worked out with your private school, right? So how much money you would have to pay, not a question I can answer. Private school has to answer that, right? Because they're the ones that are getting paid or not getting paid, as the case may be. Carter funding is a situation where you pay the tuition as the year progresses. So it's sort of what you think of that you'd have to do, right? So you, beginning of the year comes, you sign your contract prior, you come to an arrangement with them. Either you're going to pay it all at once, you're going to pay it in 3 payments, you're going to pay each month, whatever it may be, but you're going to pay it. It'll probably be paid out by spring, right? The whole thing. Connors is not like that, right? Most likely by spring, you're not going to have paid it out. Even if you have to pay installments, it's generally small installments with Connors. Then you go through the whole case that we just went through together. Connors, this district pays the school directly. So you're never out of pocket that money. It's a great option for parents that can't come up with that level of cash flow. District pays your balance. And then if you've paid anything and there's still money left in the settlement, they pay you, whatever you've paid. It requires a showing of financial need. I will say this is, again, one area where the DOE is quite kind. They are not stingy with this. Living in New York City costs a lot of money. These schools are extremely expensive. It's sort of case by case because it depends on how much tuition the school is, how expensive your program is, how many kids you have, how many kids in private school, how many of them are disabled. But by and large, people are always asking me for a bright line rule. If you make less than $150,000 a year as a family, generally speaking, there's pretty much no question you qualify for Connors. You make more than that, it depends on the situation. But if you make, $200,000 and your school's like, your program in total is 160, yeah, you'll probably qualify. So it's very much case by case, and the district is very generous. Actually, I wouldn't go so far as to say very generous. They're generous. But I think the real important thing to understand here is the private school has to agree to this arrangement. They're the ones waiting on this money. So they're the ones out the money. They're the ones that you have to get a quote unquote Connors spot with the school, right? And I know all of them would do it for as many families as they could. They would love to, but it's a financial thing, right? They're out the money all year. So you really have to talk to them first and see if they can even take you on that basis, and then come to me and say, do we qualify? And or we work together collaboratively, me and the school and the family. But remember that they have to have the spot for you. So it's not enough that you meet the income requirement. Okay. You got to find a school that's able to financially support you. For Carter, as I said, you pay the school as the year progresses. Typically, you will have paid out the whole year by, say, this time of year, April-ish, March. And then the district will pay their funds directly to you. So you paid the money and you get paid back. It's reimbursement, just like the exact definition of the word. And there's no showing of financial need. There's the IDEA protects all students with disabilities. It doesn't matter if you're, a multimillionaire. It really doesn't. There's no showing of financial need required. You pay the school. If you get a settlement or you win a hearing, you're entitled to get paid back. It's really that simple. All right, so now we get into the portion of the presentation about what's been going on lately. And I'm going to start with some of the trends that we've been seeing for the 1920 school year prior to the coronavirus, just like I was planning on doing anyway, before this all occurred. So we touched on the first issue, which is limited hearing officer appointments. I think that, this is an issue that's been major for us. We've had hearing officers that won't take cases. We had one hearing officer who took 1,700 cases. So, you know, you can imagine how easy it is to get a hearing date with him. It's been a problem. The hearing office has tried to do what they can, I guess. We're slowly getting cases, hearing officers assigned to cases with no hearing officer. As I said, as their caseloads free up a little bit, they're taking on more and more. But it's definitely been a problem. They also did a new, you know, bout of hiring. And I heard that those hearing officers have gone through their training and are now sort of listening. They were supposed to observe hearings, but obviously they can't. So they're now, I guess, listening in on these conference lines to learn more how to do hearings. So hopefully those new crop of graduates will have a whole bunch of time to take on a lot of cases. We shall see, but it is moving, but it's an issue. I'm not going to lie. The DOE has been getting a lot of bad press this year. When I started doing this, nobody knew what I did for a living. I never heard about it outside of the special ed world. Now, for a period of time before this month, I felt like we were in, or the hearing process was in the Post or the Daily News almost every week. They were getting not great press because of these issues, because of the late payments, because of the no hearing officers and the not paying hearing officers. And in my and city council also got involved. They did a hearing last year trying to sort of crack down on these problems. And in my opinion, the DOE didn't like that, and they became more sort of strict, rigid with their settlement requirements as a result of not liking the fact that people from the outside were putting pressure on them. Are they still settling cases? Absolutely. In fact, I settled a lot of cases this week, which has been amazing, but they've been incredibly, just very particular. You know, I mentioned to you before about the type of documents that they require. Now they're asking 1,000 questions for each document, and they need this, and this affidavit has the wrong date on it, and it needs to be redone, and just really stupid, ridiculous stuff. And in my opinion, because I've been doing this for as long as I have, I tend to see that when the district feels pressure from the outside, they become more difficult to deal with. I think it's almost like a small child. They're just reacting. So it has made our jobs more frustrating, more difficult. But again, cases are moving. That's my sort of line to you all. They are moving. And again, these requirements are leading to a slower settlement process, but a movement, slow movement. Hence why I said that timeline is about twice as long as it was before. There are limitations on legal fee reimbursements. I also touched on this. They're getting more stringent about, you know, typically we would, you know, send our timesheet in based on how much we spent on an hourly basis on each case and get legal fee reimbursements based on that. We are seeing the numbers, you know, they're a lot lower this year. You know, they're sort of critiquing the timesheets based on their own metric, and they're not so keen to pay out legal fee settlements. Again, we're getting them. And the more complex the case is, the higher the amounts. But, you know, they're being not so wonderful about that. But, you know, again, moving along, but it's another trend we're seeing. So the bottom line is most cases are still successful. I really do say that. I mean, and I want to sort of reiterate that because I know some of the news is grim and things have been not so great for people. I want to reiterate that most cases still remain successful. We see some type of settlement, usually very good amounts for almost every case pretty much that we have. So I don't want you to lose sight of that. Also, cases are moving. They're absolutely moving. It's just that they're slow. The most difficult cases right now, and I may have some clients on here who are in this boat listening to this, are the cases that haven't been approved for settlement and have no hearing officer. I'll be honest. Those are the cases, it's tough to move them because it's the hearing officer that pushes movement forward. And if we're not in a settlement track, they're kind of just, they're sitting. But we are getting hearing officers assigned every day. So slowly this is happening. So I just want to keep in mind, I don't want to be sort of the grim reaper and say that everything is terrible. But I have to be realistic, right? So we got to kind of talk about both things. Slow but steady progress is what I want to say for the vast majority of cases. Now, finally, we're going to touch on coronavirus. So how has this impacted our cases? So already the stuff that I just talked about were things we were dealing with through February. Now we've all been thrown into this upheaval, and I want to spend a few minutes giving you guys a sense of what the impact has been. Okay, so first and foremost, hearings and settlements are still moving. Hearings are being done over the phone. Settlements are being done by district attorneys at home. I'm actually, to be honest, slightly impressed with how well the district has, at least the legal department has adjusted to this. I hope I don't regret saying that. So far, they've been good. The DOE in particular is still working on a concrete plan for certain issues. I was hoping that by tonight I could change that bullet point and tell you that we had gotten a concrete plan, but we have not. I hear from my other colleagues that we're supposed to get some type of plan that is talks about how they plan on signing stipulations. They're basically trying to get approval to e-sign. So for those of you that are more familiar with the process and know that we have to get originals, they're basically saying, yeah, we know we can't do that. We just need the approval to e-sign them. Notarizing documents can be done electronically. The governor issued an order on that. So the district is sort of subject to that order. So they have to be okay with it. I am a notary and I'm happy to notarize any documents that anybody needs. They just need to contact me or our office and set up a time. And then I'm happy to come on Zoom and notarize for you. We do have to do it for the video. So I know some people aren't fans of that, but I won't judge, don't worry. So, I'm happy to do it. And there are still some lingering issues that I guess we're going to get more guidance on. For kids looking for 1920 reimbursement, the theme is to document everything. So you can't have too much paper, too much documentation on what is happening in terms of your remote learning plans. From schools, how are you keeping attendance? Are you marking kids in just like you would typically? Parents, if you don't have clarity from your schools on that yet, that's okay, but you should be keeping track of what they're doing each day. You don't have to write a thesis statement about it, okay? It just, a few sentences about, they did math, they had an OT exercise, then they went on for, socializing with their group, 5 kids on the Zoom. I really don't know. Clearly, I'm not a teacher, but I know that schools have been doing an unbelievable job. That's one thing I do know, and I've been hearing for all of my clients. So it's just a matter of let's make sure that we, get credit for that. Let's make sure that they're not going to prorate us at all. And they shouldn't, as long as, there's documentation. There's clear plans from the schools. Every plan I've been seeing so far from all the schools have been amazing. And just, but you want to be clear, what does my specific child do each day, right? So the overall I've been seeing is wonderful. It's a matter of you as parents, you as schools, this child did this on this day. Okay. They were present. They did all the stuff on this day. They were present on that, so just like we need to make sure, because the DOE has not been clear to us yet about what they're going to require. So you know what that means. We got to make sure that we're completely covered for whatever ridiculous thing they want us to have. God knows. In terms of services, Services should continue to be provided if you're getting a service through the DOE. If you are not getting services through the DOE, you should definitely let me know about that, because they should be providing them, okay? By that I mean it should be over the phone. I'm sorry, not over the phone. It should be audio visual. Now, say you don't have access to audio visual, okay, then it can be over the phone. I think, okay, I say that with a big grain of salt, only because I haven't gotten the notice that they've given final quote unquote approval for teleservices or services just completely over the phone. But our understanding is right now that they will give that approval as long as you can show that you didn't have access to the internet. And I think it'll be easier between you and me. I honestly think it'll be easier for sets and counseling. I think it's going to be harder for OT and PT. But then again, if you have nothing else, I still think you're going to be okay. Obviously, PT and OT, more physical things, they're going to, it'd be better if we could show audio visual. If you have no other option, you have no other option. Okay. But I need to really emphasize this point. Services should be being done remotely. Okay. If you're going to do them in your home because you and your provider are okay with taking the risk, that's your personal choice. I'm not going to, pass judgment on that, but I'm telling you right now, if you're hoping to get paid for that, you're probably doing it at your own risk. Reason being, the governor, has issued an order and he's decided what is essential and what's not. ABA, speech and language, OTPT are not essential services. And the district doesn't want to be seen as endorsing, quote unquote, things that they don't think they think are violating the law, to be completely honest about it. So if they think that you are doing something in violation of the governor's order, they're not going to pay for it. I don't see that changing. I really don't. So I think you're only, I've been talking to the other special ed attorneys, and it's come up, what if this child really cannot benefit from Zoom lessons? I think in that case, if the provider wants to, they can certainly try to seek a waiver on the governor's stay-at-home website. But I think short of that, we're going to have a tough time. So I really, really give that warning to everybody. Finally, I think my final thought on all of this is to make sure that you're planning for the future. I know that's a tall order given what's going on right now, but I also think I don't want September or October to come and parents realize they're in a tough place because they didn't plan, because not even so much they didn't plan, but they're so focused on what's going on right now that and now they got to go back to school, and their child is not in a great situation. Schools are still doing admissions. My office is still working. We're here to help you. And I think we need to keep moving forward as best as we can. So I hope that I give you some optimistic points, but I know there's a lot to be worried about right now, but I would just really urge you to not become so focused on the negative that you don't plan for next year. And I think there's no reason not to. I really believe that. We've been through some tough stuff before. This is an uncertain year. It's an election year. We've got the virus. It was already tough with some of this new stuff. But I do think that there are going to be positive changes at the hearing office. I do think that the virus will pass. And I think at that moment, everyone's going to be happy that they planned. So that's my little spiel. But I really hope people will take it to heart and plan for 2021. And again, of course, we're just trying to get through 1920. So you come to us with any problems that you have. So that's the end of the presentation. If you have any questions for me, feel free to type them in now, and I'm happy to spend some time on here if anybody has any questions. If not, and you'd rather email me, you can feel free to do that. you can see we are on many platforms: Facebook, Instagram, LinkedIn. I do YouTube videos and Twitter. And every time I do a new update on the coronavirus, I put it on all those platforms. You can also go on our website, which is ratclifflaw.org, and subscribe to us, and then you'll also get the email blast with the updates. You can feel free to reach out to me, Jennifer at ratclifflaw.org. Our phone number is still working. It's been forwarded, 646-741-3030. You can also feel free to reach out to my assistant, Fanny, if you need any time with me or you have any specific questions you want to ask to me specifically. Her email is Fanny, F as in Frank, ANNY, at ratclifflaw.org, and she'd be happy to set up a time. So I think the other thing to note is that this has been recorded. You should receive a copy of the recording. If you don't, reach out to me, because you should. And the only thing that I'd ask, you can really you can send this recording to anyone you want. Okay, but I just really be careful, please. That's the only thing I ask. I'm happy to do this program for you and hopefully try to help you. But the only thing I ask is please be careful you send it to. I really don't want it in the hands of someone who works for the DOE. That's really all I ask. So as soon as you get it, disseminate it if you want. I have a few questions and I'm going to go through them now. One of the questions is that the parents are holding off on signing contracts for next year because they're still waiting on what's going to happen this year. How long can they put that off for? That really has to do with the private school. So, talk to them and be totally open with them, and do not be afraid to be honest with them. Because they want to know what's going on, and they will, in my experience, schools will work with you. Okay. Don't be afraid to talk. I've had parents that have said, we don't want to tell them that we don't know yet. Don't be afraid. Okay. Talk to them, go to them, come to me. I'll talk to them. If you're my client, and we'll talk about where things are. And then, and they should usually work with you. These schools are wonderful, especially under the circumstances. They'll try to figure something out for you. I mean, you typically can't wait. You're going to have to by August to make a decision, right? Probably if you're a 10-month student, but do not be afraid to talk to them and to talk to my office if necessary, if you need to meet me to be a liaison. But there's no sort of bright line answer to that, right? That has to do with them because those are their contracts. Another question is about the DOE. Would they consider moving forward more quickly with a case if the parent has stage 4 cancer? Very difficult situation. I have had parents with cancer before. I actually had one or two that didn't make it, unfortunately. Not to bring down the mood, but that's tough. I want to say no, but in a way, yes, right? So you can talk to them, and usually you can get to if you're dealing with an attorney that knows the contacts over at the DOE, officially the answer is no, right? Like, doesn't really impact the case, quote unquote. I mean, I don't mean to sound heartless, but that's sort of the way. But unofficially, yeah. I mean, those are the types of facts that we could send to the legal office of the DOE and try to see if they can, if they'll make an exception, so to speak, or they'll push it along. So definitely, if you have a lawyer, reach out to them. If you don't, talk to me, and I can give you some emails, okay? And you can reach out to these people directly and talk, because reaching out to the people at the head of the legal services department, if you sort of send them an email and explain the family situation, they'll usually work with you, okay? So let me know. Another question is for students who have IEPs from the previous year, how will they update the IEP? So I think what you mean is they haven't had a new IEP yet for this coming year. I hope that's right, but if it's not and you want to clarify, feel free. So they're gonna have IEP meetings over the phone, like I said. So they'll reach out to you for a new IEP meeting and they'll do it over the phone. And it'll be like any other IEP meeting, but just over the phone. That's how they'll update it. Or they may not, because as I said, and as we know, sometimes they don't give updated IEPs every year because they don't do what they're supposed to do. So if they don't and you really need one, I would say reach out to your attorney. Reach out to me. If you're going to a private school next year and you don't care either way about the IEP, it's not going to matter so much. But again, reach out to your attorney to talk about the implications of that. And I'm happy to discuss it with you. But generally speaking, if you need an updated IEP, they're doing it over the phone. Okay. Those are all the questions that we have, unless anybody has any more. I'm going to stay on here for the next 10 minutes or so. If anyone has any more, I'll answer as they come. Otherwise, I just want to thank everyone again so much. I know this is like a huge imposition with what everybody has going on. And again, you should get a recording. If you don't, please reach out to us. I'd say by Monday if you don't have it, and you can feel free to disseminate it, like I said, but just really please be careful for my sake. I just ask to be careful who you send it to, that's all. So thank you all so much. And like I said, I'm going to keep the webinar open until 7:30 in case anyone has any other questions, and I'll answer them. Okay. Thanks, you guys. Please stay safe and have a fantastic rest of your evening and hopefully great weekend. Okay, thanks. So the next question that I have is it unrealistic to pursue an IEP at this time if a child doesn't have one currently? Yes. Well, yes, I would not hold off at all, actually, to be completely honest with you. There could be implication, again, things, you don't know where we're going to be in October. And if you don't have an IEP, you may have, you may make your case more difficult. So I would say don't hold off. I'm happy to talk to you separately about the specifics of the case in terms of, is this a child that wants district services? Is this a family that's looking more towards the private end of things? Because that sort of tempers the approach. But I would say do not let it discourage you. The current situation, because if they don't, they still have obligations under the IDEA. So if your child doesn't have an IEP, or the child you're working with doesn't have an IEP, and they need one, they need to give it to you. I think there's talk lately, there's concern that they're going to be waiving certain special ed rights under the coronavirus, some of the coronavirus legislation, but they have not done that yet. And I'm skeptical as to whether or not they're going to be able to get something like that passed, especially in New York with our Democratic leadership. So I would say do not let it hold you up, because they still have those obligations and you can still make a case. So I hope that answers that question. But if not, feel free to reach out to me separate and we'll talk more specifically. In answer to the question about whether or not I work with Long Island families, sometimes I do, depending on the district, depending on the family and the circumstances. Um, yeah, I mean, I wouldn't say I don't. So, I mean, I have a lot less in Long Island. Obviously, obviously I'm a New York City based attorney, but I'm happy to talk to you about it. Yeah. So just reach out to me and we can talk. Okay, guys, that's all that I have. So if you have any more and it was like too much to type or too private, feel free to email me, okay? Or call Fanny and we can set up a time. All right, thank you so much, you guys, and have a great night.